Thank you. It is great to be back here at the Balsillie School to be able to join you. This is actually 6 weeks after my January conversation talking about U.S. national security and its impact on trade. And so 6 weeks now, given the pace of events, feels sort of like 6 years. And so I want to start by really focusing in. And what I've been working on quite heavily with respect to this talk is to situate where we are in the context of a very, very busy environment. And so let's just start with a sanity check. I think it's always a good thing, actually, to just sort of get our hands on things. Close your eyes for a second, unless those of you who are remotely are driving, then please do not do that. But otherwise, picture the words in your mind, Supreme Court victory. Now, what do you see? Probably headlines, right? Probably Ottawa celebrating, like when we got into the semifinals for the Olympic hockey, right? Probably commenters saying that the rule of law held and that the president's hands are now tied and Canada can exhale. And here's the problem with that picture. It's wrong. And the reason it's wrong matters enormously. Because if Canada spends the next 5 months celebrating the wrong victory, we're going to walk into the July CUSMA review completely unprepared for what's actually awaiting us. Now, the president didn't lose his leverage from the Supreme Court decision. Foundationally, he just lost a lever. Now, that's what I told Bloomberg News the day the ruling came down. And let me show you exactly what I meant. Okay. Got it. So here's what happened. The Supreme Court ruled 6-3 that the Trump administration could use the International Emergency Economic Powers Act, IEPA, as the legal basis for sweeping Liberation Day tariffs. Big ruling, constitutionally significant, and yes, the rule of law won. Okay, as a law professor, very happy about that. Now, the foundation of the majority decision is as old as the U.S. Republic. The power to lay and collect duties belongs to Congress. That's in Article 1, Section 8 of the Constitution. It's not with the president. Okay, so Chief Justice Roberts applied what lawyers called the major questions doctrine. That's a principle that says that the executive branch cannot claim vast new powers from a vague statutory language without a clear congressional mandate. Yeah, you need to have something from Congress if you want to go there. And Chief Justice Roberts pressed the government's lawyer directly in the hearing. So if the president can impose tariffs under the statute, how far can this go? Under the same logic, can the president impose personal income tax by an executive order? The government's answer at that time was super evasive. And Justice Roberts found that telling. His conclusion, using IEPA to impose a global tariff regime, is like using a fire alarm to rewrite the building code. The tool and the task don't match. Now, at the WTO, we have different tests and different ways of looking for nexus and reasonableness. We don't have that generally in constitutional law. And so Justice Gorsuch took a slightly different approach. He went further. His concurrence said, if the president can declare a trade emergency to impose tariffs, what stops the next president from declaring a climate emergency and slapping a 50% carbon charge on every import? Now, that's not hypothetical. That's a warning about what normalized emergency governance looks like over time. The founders gave Congress the power of the purse for a reason. And that was clearly constitutionally in the text, so that's what we knew. And Justice Kagan added the historical nail in the coffin, because when Congress wrote the IEPA legislation in 1977, it deliberately removed language relating to the power to tax. And that was a choice, right? The administration's claim that the word regulate secretly included the power to impose tariffs ignored what Congress actually decided. You don't give up your core constitutional power through silence. That's the same in Canada, it's the same in the UK, and it is essentially core to US constitutional jurisprudence. So 6 justices, cross-ideological in nature, one of the most consequential trade decisions in the modern era. But there's a dissent. And the dissent is perhaps the most important part. It really is. So I want to take you through it. And here's what most of the coverage missed. 3 justices dissented: Justice Thomas, Justice Alito, and Justice Kavanaugh. And they didn't dissent by arguing the president should have unlimited tariff power. That wasn't the basis. They dissented on institutional grounds, essentially saying it wasn't the court's place to second guess an emergency judgment by the political branch. And this was a tension, by the way, that goes all the way back to Thomas Jefferson, okay, about this special power. But then Justice Kavanaugh wrote something special, something that should be printed and pinned to the wall of every office and every trade ministry official in Ottawa. Said, although I firmly disagree with the court's holding today, the decision might not substantially constrain a president's ability to order tariffs going forward. Okay. Then he listed why. He gave a roadmap. He named the alternative statutory tools by section number. If they weren't smart enough to figure it out in the first place, he gave them the numbers. Sections 122, 201, 232, 301, 338. He was essentially handing the US administration a roadmap, what I call a dissenter's guide to what to try next. And even Justice Alito, normally a firm defender of executive discretion, conceded during oral argument that the president may have other legal tools. And Justice Alito dissented anyways, also on institutional grounds, but not because he thought tariff power was unlimited. So the practical results, within hours of the ruling, the White House had already invoked Section 122. Kavanaugh's dissent told them where to go. They went there immediately. And if we watched the State of the Union last night, the president mentioned that yet again. He said legally tested. It wasn't legally tested, but it was pointed out by Justice Kavanaugh. So let's look at what happened the following morning. Okay. The legal tool changed. The strategic intent did not. The president held a press conference. He was defiant. 3 presidential actions followed. Okay. 1, ending the IEPA orders. 2, reimposing tariffs under Section 122. And then continuing the suspension of de minimis treatment, something that's really very significant for small and medium-sized businesses across Canada. He warned that every country that had negotiated a deal under the IEPA framework, that those deals must stand or new tariffs would follow. Now, the Canada-US Trade Minister, Dominic LeBlanc, declared the ruling confirmed that the tariffs had been unjustified. And after that, Ottawa said very little. Very little. Given how much pain has been caused to Canada, there was an act of extreme composure. But here's what that silence didn't change. Steel tariffs still in place, aluminum tariffs still in place, automotive tariffs still in place, lumber tariffs still in place. None of those were IEPA tariffs. And the Supreme Court's ruling didn't touch them. Not one of them. So think about this for a moment. The tariffs doing the most damage to most Canadian workers, the ones hitting the steel mills, the aluminum smelters, our auto plants, they were never IEPA tariffs. We celebrated a ruling that was entirely irrelevant to our worst pain. So the legal tool changed, but the strategic intent did not. So we need to think about the architecture of leverage. And first, we got to think about how we got there. How did we get into a position where the United States has a warehouse full of trade weapons and Canada shows up with a strongly worded and very polite letter, but nothing else? And the answer is design philosophy. And it goes back decades. This is not new. This goes back for a long time. The CUSMA, foundationally, is a permission slip. It's not a partnership. Let's go look at that. Okay? I want you to think what a trade deal actually is. In the old world, and by that I'd call it the 1988 version, okay? Not to make myself too old, but I remember those days. A trade deal was about access, okay? You lower taxes at the border, goods move freely, prices went down. Simple, clean, everybody wins, right? But here's what we learned from Jared Kushner, because he admitted this in 2020 after the first Trump term, and he was involved in drafting and the architecture of the CUSMA. And it's something I've been talking about a fair bit. CUSMA's 6-year sunset clause was designed as, and I'm quoting him directly, a 16-year lease, a mechanism for recurring leverage. He made it very clear it was about extracting profits from a weaker party. But every 6 years from the beginning, or I think actually it could be every year by the design of how it's there, Canada comes back to the negotiating table as a supplicant. Our entire export economy is the collateral. Now, that's not a trade deal. That's a permission slip. And permission slips can be revoked by the principal at any time. That's why I wouldn't recommend that that's what we do going forward. Now, Article 32.10, what I call the poison pill, that's a provision in the CUSMA that requires Canada to give 3 months' notice before negotiating any trade arrangement with a non-market economy. Now, in treaty language, non-market economy could be a variety of spots, but really we all understand that to be China. The provision does not restrict Canada from pursuing market economy deals with the UK, with India, with the CPTPP bloc, with Japan, Australia, all the places where the Prime Minister is going this week. But it gives Washington an effective veto over any Canadian trade initiative directed at China. And if they don't like where we're going, they can terminate the CUSMA and replace it with a bilateral US-Mexico deal. Canada gets expelled from the trading bloc that we helped build. And 3210 allows them to name, shame, and blame Canada for pulling it out. They don't need a reason. Remember, there's another provision that allows them to cancel the law in 6 months, but this lets them blame Canada and withdraw it. And the digital chapter, something I'll come back to a little later on, doesn't just govern trading goods, because it prohibits data localization, protects US platform source code from audit, and imports the Section 230 liability shield directly into Canadian law, something that wasn't in Canadian law before. And that's not a trade concession. It's really a constitutional concession dressed up in the trade agreement. In other words, we allowed more extensive sovereign restrictions on our economy through these additional provisions. And there was not a lot of discussion about it. And when I've talked to people who negotiated, they actually didn't think it was really going to be a problem. They thought it was a good idea. Let me tell you, it was not a good idea then, and it's a terrible idea now that we have a significant digital economy. So why did Canada build a defensive system in an offensive world? So first of all, the US 2025 National Security Strategy doctrine made this all very explicit. Because here's the deeper problem, okay? The US built its trade laws over the course of 40 years with one explicit goal: to project power, to force other countries to change their behavior. And that system is fundamentally offensive in nature. And Canada built its laws to manage a relationship. We optimized for access. We wanted to make sure the border stayed open so we could sell our stuff across it. And that seems very reasonable. It was reasonable for a long time. But when you optimize for access, you don't have the capacity to push back. You end up relying on the other side liking you. And for a long time, the other side liked us. But here's the hardest truth of all. Goodwill doesn't survive elections. Goodwill doesn't have to be permanent. And so in November 2025, the US, when it released its national security strategy, I analyzed it in the National Post newspaper shortly after it came out. And I said it should frighten Canadian policymakers. The strategy announced the Trump corollary to the Monroe Doctrine, American preeminence over the Western Hemisphere, including authority over what it calls strategically vital assets, and declared that agreements with countries that depend most on the United States must be sole-sourced contracts for our companies. And US Trade Representative Greer said on December the 10th at the Atlantic Council that European digital regulation was an attempt to set local rules for American platforms. And his response was, quote, "We're not going to allow that regulation to be outsourced," end quote. Now, the same logic applies to Canada with even greater force. So Ottawa has to read the doctrine. It can't just read the smiles from the photo ops and assume that that's going to stay, because it doesn't. In fact, I don't even know if we get smiles in the photo ops anymore. Okay? But the mistake Canada's made, and repeatedly, is treating each episode of US pressure as an isolated event requiring an isolated response. And the US response is not episodic. It is systemic. Leverage is not a single instrument. It is a weather system. Okay? It's like one of those bomb cyclones of snow that we've just gone through. IEPA was just one feature of that weather system. The Supreme Court removed it. The climate hasn't changed. Where you want to be. So let's focus in on the arsenal that remains. Okay, let's just take an inventory, because you can't develop a responsive strategy without a clear-eyed account of what you're actually facing. Think of it this way. The Supreme Court took away a sniper rifle away from the US president, but it left him a tank, a bazooka, and the entire armory. Now, I've sometimes described it as what Batman wears, a bat belt full of all these little goodies. Okay, let me walk you through what's still in the building. Okay, so Section 122 is what we might call a bridge tariff. Okay, this is Section 122 of the Tariff Act of 1974. This provision had never been used to impose tariffs in the history of a statute until the day of the Supreme Court decision, February 20th, 2026. And it authorizes the president to impose a temporary import surcharge of up to 15% for up to 150 days for a particular purpose, to address a large and serious balance of payments deficit. But no investigation is required. No agency finding is required. No hearings have to take place. The president acts unilaterally and immediately. And so within hours of the IEPA Supreme Court ruling, President Trump invoked it. And by the following day, he claimed to raise it to the maximum. Originally, he said 10%, then he raised it to the maximum of 15%, effective February 24th. But in fact, he actually only imposed a 10% tariff in the paperwork. So I guess that's a good thing, I guess. But the clock is now running. 150 days go. So it expires on July 24th, 2026. Now, there's a structural protection for Canada that matters here. The proclamation exempted goods entering right now, duty-free under the custom, and the vast majority of Canadian trade qualifies. So in that narrow sense, Canada's customer-compliant exports are insulated from Section 122 surcharge. Okay, that's good. But first of all, the 122 duties don't stack, they don't relate to the Section 232 duties. So Canadian steel, aluminum, copper, lumber, and automotive products already subject to Section 232. They continue along the Section 232 duties. The 122 exemption does nothing to help them. More importantly, you got to listen to Treasury Secretary Bessent. He described Section 122 and he called it a bridge, a 5-month runway while the Commerce Department and the USTR complete Section 232 and Section 301 investigations designed to reimpose the very same tariff levels through more legally durable authority. The words of Secretary Bessent, he said, Treasury's estimates show that the use of 122 authority combined with potentially enhanced Section 232 and 301 tariffs will result in virtually unchanged tariff revenues in 2026. Now, this is critical. The timing is critical. Section 122 expires July 24, 2026. That's just within days of a July 1, 2026 customer review trigger. So the alignment, I think, is not an accident. And I think it helps explain why Canada has remained with the exemption. Now, Section 232 and 301 expansion needs to be also looked at. Section 232 for national security tariffs was never touched by the ruling. All of those tariffs I talked about are still in place. The Commerce Department is still being directed to complete new investigations within the 150-day Section 122 bridge period. What are they on? Dairy, HST, digital regulation, semiconductors, advanced materials, critical supply chains, all are in the pipeline. And Section 301, which deals with unfair trade practices that would violate the terms of an existing trade agreement, basically need the customer around to help use that to justify the 301 tariffs. Now, it's also being weaponized on a scale that we've never seen before. And on February the 20th, the U.S. Trade Representative announced multiple simultaneous investigations covering most of the U.S. trading partners. And that includes things like Canada's digital services tax, the one, remember, that we abandoned. So we enacted it, and then we abandoned its effectiveness about in 48 hours in June of 2025. Now, that was threatened again under Section 301. The Online Streaming Act, the Online News Act have been flagged as targets either both by the national security side, 232, or in the 301s. So the lesson that we learned from the digital sales tax should be permanently embedded in every Canadian trade policy document. Capitulation does not extinguish the threat. It confirms the pattern. When you fold, you teach the other side that the threat works. So, what does the customer Article 3210 trap mean? Okay, because you would think we want to diversify. We do want to diversify. And Prime Minister Carney did a major China initiative, trading EV market access for canola and some seafood tariff relief. But that activated Article 3210 in the most explicit deployment of that provision that I've ever witnessed. And 100% tariff threat was immediately imposed. Okay, I want to be precise about something. And this matters very much for the upcoming July review. Article 3210 applies only to non-market economies. And the one that counts is China. And that's the treaty language. It does not restrict Canada from pursuing free trade agreements with market economy partners. And there are many, many market economy partners where Canada has a lot of space and a lot of opportunity and should be doing things, okay? The China reset failed not because diversification was prohibited. It failed because it was directed at the one category of trading partner that Article 3210 specifically was designed to catch and pursued without Canadian countervailing leverage to make that bet defensible. And so the deeper lesson from the China episode is what I called layered risk. By attempting to diversify towards China to reduce dependence on the US, Canada didn't reduce its risk. It doubled its risk. It doubled its exposure because now Canada's vulnerable to pressure from both Washington and Beijing simultaneously. And that's not diversification. That's basically picking up nickels in front of a steamroller. That's a very bad policy. So we have the Bombardier example, which doesn't really get enough attention. And this year, the FAA withdrew certification recognition from certain Bombardier aircraft in the US. The implicit condition for restoration was Canadian certification of US Gulfstream aircraft. Now, this is a regulatory tool, aircraft certification, weaponized for trade leverage, not a tariff, okay? Not IEPA, not touched by the Supreme Court ruling. It's what the US arsenal looks like when it goes beyond trade law entirely. So leverage is not a weapon. Leverage is a weather system. You don't respond to it with an umbrella. You have to build a shelter. And so that's what I want to focus on. I want to focus on vulnerability. Now, before I turn to what Canada can do, and I'm an optimist and I actually think there are things that we can do, I need to be honest with what Canada is dealing with. Some structural vulnerabilities that constrain virtually every response that we have. Vulnerability one are the dependency numbers, okay? So Canada sent in 2024 approximately 75.9% of its export goods to the United States. By 2025, it had been reduced to 71.7% on an annual basis, the lowest share since the early 1980s. And in Q4 of 2025, the monthly figure touched 67.4. That's because of the sectoral tariffs, right? The impact of sectoral tariffs significantly reduced trade flows. Now, I want to be very balanced about this. The decline represents some real diversification taking root as well, right? Gold exports to the UK and Switzerland are surging. There's some reasons for that. I don't have to go through them. I don't know if that's going to be a permanent basis, but for sure, they were very, very active. Crude oil exports to Asia were increasing. Exports to non-US markets rose 17.2% in 2025, and that is a meaningful start. Okay, so that's really important. But the exports specifically targeted by US tariffs fell sharply anyways. Steel exports were down 24%. Aluminum export volumes were down 15%. Forestry was down 8%. So we made progress at the headline level, while the sectors under direct attack continue to bleed. And that asymmetry is reduced, but it's nowhere is it near resolved. So now we need to think about our second vulnerability, okay? That is, if I get the second one up here, yeah, vulnerability two, you got it. We own the pipes that other people control. Let me explain that. There's a concept here. First, I want to talk about it's the Cloud Act. Now, most Canadians hear cloud and they think about their iPhone photos backing up, right? But the Cloud Act is a 2018 US federal law that says something very specific and very alarming. It says your data, your banking records, your health data, your company's intellectual property that's stored on a US-based service provider or by a Canadian company with minimum US contacts can be legally accessed by US authorities regardless of where that server physically sits. So here's the assumption that most Canadians make. If my data sits on a server in Toronto or here in Waterloo, Canadian law applies. Geography equals jurisdiction. Absolutely intuitive. Very reasonable. Unfortunately, it's now wrong. The Cloud Act says jurisdiction follows the company, not the geography. It's an extraterritorial effect. So if Amazon, Microsoft, Meta, or Google holds their data on servers physically located in Canada, US courts can compel them to hand it over. But this also applies to Canadian companies that meet the minimum contact rule in the US. And that appears to apply to companies like Bell, TELUS, and Rogers as well. We have foundationally ceded control over our digital border. And unlike a physical border, we didn't have a ceremony when we did it. We just clicked, I accept on the terms of service. Now, let's add this. Canada accounts for only 1.8% of AI-related patents globally, despite holding 10% approximately of the world's top-tier AI research talent. So the pan-Canadian AI strategy has been busy training world-leading researchers. 75% of the patents generated through the strategy accrue to foreign firms. So we produce the talent, we fund the research, someone else owns the research. Someone else owns the harvest. That's the patent. Then, as Jim Balsillie has put it, we have a policy orientation fit for a tangible world, but we now live in an intangible world. The rails of tomorrow are being laid today. And if we don't own them, we travel through somebody else's empire and we pay them handsomely for that privilege. And that is a very, very deep problem. Make it even clearer. Okay, the trillion-dollar gap. Okay, now Jim Balsillie was drawing on work from economist Dan Churiak, someone who's done work here and over at CG on his economic modeling. Mr. Churiak used to be the chief economist at what we now call Global Affairs Canada. It might have been External Affairs at the time. And he puts a number on what Canada's failure to capture the value has cost us. And since 2010, the beginning of the data-driven economy, if you want to deal with it, the US has grown its GDP by 103%, and Canada has grown by 38%. So if you make that on a base of 100 comparison, in other words, say one's 100, the US is at 203, while Canada's at 138. Now, applied to our 2010 GDP, the divergence here represents between $500 billion and $1 trillion in foregone prosperity to Canada. So that's a gap that's not attributable to geography or to natural resources. It's attributable to strategic choices, specifically the failure to own and retain the IP in sectors where the 21st century economy is actually being won. So $500 billion of foregone prosperity, I think that's a staggering number. But there's another way to read this. $500 billion in recoverable opportunity. Okay, the gap's diagnosis. The prescription exists. There's a path that we can follow. So I want to be direct about something before I finish up here. Now, because I've spent roughly the last 35 minutes describing very serious problems, but I'm not here just to describe problems. Okay, I actually think Canada has a genuine cause for optimism. Not complacency, optimism. The research capacity is there. The institutional foundation is there. The economic opportunity is there. What's required is strategic will to make the choices that sovereign economies make. So let me give you 5 concrete things that we can do. Okay, 5 actions that Canada is taking. I'm sorry, it's hard to read here in the room. Action 1, fast countermeasure legislation. Build the deterrent. Now think about what happens right now when the US slaps a 10% tariff on Canadian aluminum at 8 o'clock in the morning. Okay, what does Ottawa do? It calls a meeting, right? In fact, it has 10 more meetings. It has meetings with the provinces, it has meetings of its own, it has meetings with the trade commissioners, it has meetings with the industry representatives. Then it goes to cabinet, right? And they consult even more stakeholders. They run economic models. They draft regulations. It takes weeks. Actually, it takes months. Okay? That's the process. Here's the problem. Meanwhile, the aluminum plant, for example, are shutting down. The contracts are evaporating. The damage is immediate. The response is delayed. That's asymmetry, and it's not an accident. It's a structural advantage that the US has built into the system. So what Canada needs is a Sovereign Economy Act, a standing legal framework that allows snapback countermeasures within days, not months, days. This is deterrence theory applied to trade. If the US negotiator knows that hitting Canada produces immediate automatic economic pain for US exporters, they factor that into the strategic utility calculus before they act. If they know Canada will spend 3 months consulting internally, they have a free window to apply pressure. And pressure works. We've seen that. So predictable restraint on the part of Canada, because we're nice, is an invitation to be bullied. So this legislation can be built within a single parliamentary session. The foundation already exists in the Emergency Management Act, the Investment Canada Act, and our existing retaliatory tariff frameworks. We're not starting from zero. We're filling an architectural gap. Second, we need to enter the July customer review with a strategy, not with hope. Now, Mexico, in many respects, has showed us how to do this. I just came back from Mexico. I had a chance to meet with our overworked, very, very able trade negotiators in Mexico. I had a chance to meet with the Mexican bar, the Mexican business community. So let's just think about it. Same geography with the US, so to speak, right? Same neighbor, same dependence on the US economy, a little bit less, but very, very different strategy, right? Mexico figured out something that Canada hasn't figured out. Okay, they understand that Trump-style executive leverage operates strength to strength, principle to principle. They didn't waste time arguing about fairness or quoting the spirit of the agreement. They looked at what the other side wanted, specifically on security and on migration, and then they traded it fast, tangibly, and without any public moral confrontation. Now, Canada spent a lot of time standing at the podium lecturing Washington about shared values and the history of the relationship. Okay, it felt good. Elbows up, felt really good. But Mexico went to the back room and cut a deal. And we confused being right with having power. Mexico just tried to close the deal. And pragmatism has saved them a lot of pain. We have a lot more pain with our trade relationship with the United States. We have a lot more workers that are feeling it in Canada than in Mexico. And here's what I want Canada to bring to the July review. 3 specific and achievable priorities. First, reform of the digital chapter. Restore the policy space to govern data, algorithms, platform accountability. 2, clarification of national security exemptions that allow Canada to build sovereign compute infrastructure without a CUSMA challenge or whatever they're going to call the new agreement, because I don't think it's going to be called CUSMA. Third, institutional reforms that strengthen our trade advisory architecture, a reconstituted National Trade Commission with hundreds of security cleared sector experts, not improvisation. The Americans have 1,000 of them available, all connected, able to deliver to the moment information, data, and evaluation to the trade negotiators. We have none. And remember that CUSMA Article 3210 does not restrict market economy diversification. It's good. We're open to the UK, we're open to India, we're open to the CPTPP and the Indo-Pacific Strategy, we're open to the EU, we're open to anybody, okay? All of that is open. The China reset failed not because diversification is wrong. It failed because it targeted the one partner that Section 3210 specifically addresses, okay? The lesson is not don't diversify. The lesson is diversify towards partners that Article 3210 doesn't cover. That's the lesson. And action 3, legislate before you negotiate. Negotiating positions without domestic legal architecture is rhetoric. Canada has to legislate before it negotiates, and the area I'm talking about, of course, is digital. A Digital Sovereignty Act establishing clear statutory authority over data governance, algorithm auditing, cloud sovereignty, AI accountability, does all these 3 things simultaneously. And it gives our negotiators a mandate and a fallback. And it signals to our trading partners that Canada is serious about governing its own digital economy, and it establishes the legal foundation for the sovereign compute infrastructure that is a precondition for competitive value-added industry. Now, Switzerland's Apparatus initiative proves that this is achievable for a small open economy. Switzerland built a sovereign, open, multilingual, large language model, sovereign compute, integrated into national supercomputing clusters and insulated from foreign extraterritorial claims. Canada, with a deeper research base and a larger economy, can do better. But we've done none of that. Action 4, own the harvest. The US never apologized for the Bayh-Dole Act. And that law ensured that federally funded research results in American-owned patents. Canada funds world-class research while watching the patents leave for Silicon Valley. That is a policy failure. It is not an inevitability. What we need in Canada is a deliberate policy of IP retention, procurement rules that preference Canadian-held IP, patent holding structures that keep commercial value in Canada, and commercialization pathways that make it more attractive for a Canadian AI researcher to build a Canadian company than to sell it to an American acquirer. And that $1 trillion gap I talked about is a diagnosis. IP retention is part of the prescription. So, here. Oops, sorry. I seem to be hitting the buttons. Yeah. Diversification is necessary. The data shows us that it's beginning, but it has to be pursued with discipline, not as a panicked reaction to American pressure. The pressure is not going away. Real diversification means deepening our CPTPP relationships. Japan, Singapore, Australia, New Zealand, all sectors where Canada has a genuine competitive advantage and an opportunity to be able to make deals get done. It means critical mineral supply agreements with European partners seeking to address their own dependencies. It means building the institutional infrastructure to support Canadian firms in markets beyond the continental default. But the US respects countries that can say no. It pays little attention to those that must say yes. That's the foundational point we got to get ourselves beyond. So let's just focus at the nature of the game as we finish up. So let me close with the frame that I've been quoting. The Supreme Court did something genuinely important. It affirmed the American constitutional order has real limits. It reminded us who taxes governs, and that the founders of the US Republic gave the power to Congress for a reason. The rule of law in the US is not dead. It showed up, finally. And now I'm hoping actually that Congress shows up also, finally. But the rule of law in the American courtroom is not the same as the rule of law in the trade relationship with Canada and the United States. I don't think it's practical for Canada to litigate its way to security. The WTO dispute settlement system has been effectively paralyzed. Now, I am still hopeful that it is going to come back, but right now it is effectively paralyzed, and that allows trade might to defeat trade right. Customer dispute settlement panels operate on timelines that provide no relief from acute pressure, and even a legal victory can be overridden by a credible enough threat. So the lesson is not to abandon law. Law matters. Law creates constraints, it builds expectations, and it generates consequences. The lesson is this: law without leverage is an argument without a voice. It's technically correct, but it's practically inaudible. And in modern trade, access does not equal strength. For 40 years, Canada thought if we had just had access to the market, we are strong. But the reality is ownership equals power. If you own the tools, you write the rules. If you rely on somebody else's tools, you're subject to their rules. And it doesn't matter whether we're talking about steel mills or cloud servers. If you aren't bringing leverage to the table, you risk yourself being on the menu. And the biggest risk here isn't making the wrong deal. It's delay. Every year, Canada delays building sovereign tools countermeasure legislation, domestic digital infrastructure, IP retention frameworks is another year of eroding position. That's erosion. The frontier of jurisdictions moving fast. The US is legislating, Europe is legislating. Doing nothing is the most dangerous move on the board. So Canada's task is not to win a legal argument with the US. It's to build a strategic position from which legal argument can actually be heard. The president didn't lose his leverage from the Supreme Court. He lost a lever. Our job is to make sure that the remaining levers are harder to pull.
Thank you so much, Barry. And I would just summarize, if I may. So the power is at the core of this, and perhaps more effort directed at where could you exercise whatever limited power you have to make it hurt. That will get attention, as opposed to let's just be nice guys. And I'll give you two examples that may or may not work, and you have to play it out. Oil exports from Canada into the United States, a very large 4.5 million barrels per day, is a strategic lever that can have immediate price impacts in the US gasoline sector that you would find it unwilling to just close it. But you wouldn't do that. But that's one. Steel you mentioned. Aluminum is what I meant. There is not much production capacity in the United States for aluminum. They need the stuff we have. And so if they put the tariffs on it, I would say double it up and see what it feels like in terms of cost to your own producers. And you'll find out very quickly that they wouldn't do that. So there are, and I've just put out two, just for as thinking to say, there may be things we can do that addresses your question, which is at the core of it. It's power, exercise of power, strategic power, and which part of it do we have that may or may not have more resilience than just saying, let's be nice and have you not been good boys all these years. So anyway, that's
well, all I want to say is how delighted I am that I can be in a place where we're actually having this discussion, where we're able to think about these thoughts, where we can share different approaches and build capacity and intellectual approaches and practical approaches for the very serious issues that we have in this country. And I thank you and the Balsillie School for the opportunity to let me think about them, to let me share these ideas with you, and to see if we have ways that we can really help deal with what's a very, very serious and challenging issue. And so thank you all very, very much.